Hello, my name is Esther Childs, and today I will be presenting Assessment 2, Solving a Legal Problem. On the 15th of December 2021, the Premier declared a pandemic in relation to COVID-19. Pandemic under Part 8A of the Public Health and Wellbeing Act 2008. This declaration enables a Minister of Health to issue pandemic orders that may place obligations on businesses and individuals in Victoria to protect public health. Persons may be authorised under the PHW Act to support and comply with the enforcement of the pandemic orders. The following case involves a company that has been found to have breached the Public Health and Wellbeing Act, Victoria 2008. Firstway Limited, a supermarket chain, operates throughout shopping centres across Australia. The chain is managed by Peter, the managing director who holds majority shares, and James and Brian, the other two directors. There's also Leslie, who acts as the company's general counsel. The company has been fined under Victorian legislation. Follows are the main issues. New legislation introduced by the Victorian State Parliament requires wearing masks as a mandatory requirement in shopping centres. Upon discussion, Peter and James, with the presence of Leslie, decided to not implement the new requirements within Firstway stores. Brian was later informed and agreed to the decision. I will be advising only Peter and James on this matter and will answer the following questions. What laws has Firstway breached? Why has Firstway been fined? And have Peter and James breached their director's duty of care and diligence owed to the Firstway Limited under Section 180 of the Corporations Act? There are several laws that are involved in this matter, and they are as follows. The Public Health and Wellbeing Act, Victoria 2008, and under this Act, Part 8A, Division 3, Pandemic Orders, Part 8A, Division 6A, Offences, Penalties and Related Matters, and subordinate legislation of the Public Health and Wellbeing Act, Victoria 2008, the COVID-19 Compliance and Enforcement Policy. We have the Infringement Act, Victoria 2006, Division 2, Section 12 and Section 16. And lastly, we have the Corporations Act 2001, Section 180. The first issue we will discuss is Issue 1, the failure to implement face mask wearing requirements. Under the Public Health and Wellbeing Act, Division 3, Pandemic Orders, a person commits an offence if the person refuses or fails to comply with a pandemic order, or with a direction given to the person, or a requirement made of that person in the exercise of pandemic management power. This leads us to the infringement and suspension issues surrounding the case. Issue 2. Firstway has been fined $1 million from the Victorian Department of Health and a suspension of trading for 30 days. Now, under the Compliance and Enforcement Policy, Section 231A of the Public Health and Wellbeing Act, enforced by the Victorian Department of Health, there are two levels to the infringement. There are Level 2, which is infringement notices may be issued where there is a prima facie evidence that a breach of a prescribed offence has occurred and there is no reasonable excuse. This is generally used when it is not deemed to be of a level that requires a court appearance or disciplinary action. That is, the breach of less serious nature, and there is no mitigating or aggravating circumstances. But there is a high level of public concern about the intensity of the issue. Infringement notices should not be issued unless the AO issuing the notice has had a conversation with the person and the offence and ascertained whether the above factors apply before issuing the notice. Now, Level 3 of the infringement. A prohibition notice may be issued if there has been a contravention of the Act or associated regulations which is serious and has created an immediate and imminent risk to large-scale public health. Probation notice requires an alleged offender to cease carrying on an unsafe activity. This leads into Issue 3, potential breach of director's duty of care and diligence. Under Section 180 of the Corporations Act, care and diligence, under point A of the Act, it states, where a director or officer of a corporation in the corporation's circumstances and B. occupied the office held by and had the same responsibilities within the corporation as the director of the office. Now, there's also a section, the business judgment rule. The director or the officer or other officer of the corporation makes a business judgment is taken to meet the requirements of subsection A and their equivalent duties at a common law and equity in respect of the judgment. Now, Section 2 of this, a director or other officer of a corporation who makes a business judgment is taken to meet the requirements of subsection A. A. Make the judgment in good faith for proper purpose. B. Do not have material personal interest in the subject matter of the judgment. Or C. Inform themselves about the subject matter of the judgment to the extent that they reasonably believe it to be appropriate. Or D. Rationally believe that the judgment is the best interest of the corporation. The directors or officers believe that the judgment is in the best interest of the corporation is a rational one, unless the belief is one that no reasonable person in their position would hold. Now, there are possible defences for first way, and they are as follows. Issue 1. Failure to implement face mask wearing requirements. They may plead not guilty under point 2 of the Public Health and Wellbeing Act, Division 6A, Offences, Penalties and Related Matters. It states, a person is not guilty of an offence under subsection 1 of this Act if the person has a reasonable excuse for refusing or failing to comply. Under Issue 2, $1 million fine from the Victorian Department of Health and suspension of trading for 30 days. Under the Refrigerant Notices Act 2006, Division 2, Section 16, a person may elect to have the matter heard in court. Then Issue 3, breach of director's duty of care and diligence, may plead under the Business Judgment Rule. Under the Corporations Act 180, Business Judgment Rule, it states that C, if the directors inform themselves about the subject matter of the judgment to the extent they reasonably believe it is appropriate, or D, rationally believe that the judgment is in the best interests of the corporation. Now, in conclusion, after these findings, I've listed what I think would be the likely outcomes of all three issues. Issue 1, it is highly likely that First Way Limited has committed offence under the Public Health and Wellbeing Act, Part 8A, Division 6A, Offences, Penalties and Related Matters. It is highly unlikely that Peter and James will be able to plead not guilty under Section 2. This is clear evidence of the offence and an eyesight witness. Issue 3, although Peter and James, as directors of First Way Limited, may elect to have the infringement noticed and suspension matter heard in court, it is highly unlikely that the matter will be dismissed. Peter and James could argue they were acting in good faith on the advice of their General Counsel, Leslie. This brings us into Issue 3. James and Peter could argue they had C, informed themselves about the subject matter of the judgment to the extent that they reasonably believe it to be appropriate, or D, rationally believe that the judgment is in the best interest of the corporation on the advice given to them by their General Counsel, Leslie. It is reasonable to say that Peter and James may not be as fully accountable for the breach of the Corporations Act 2001-180 care and diligence. It would be advisable for Peter and James to seek compensation for damages due to incorrect advice given by Leslie. I thank you for your time and I hope you enjoyed this presentation.